Okay, so welcome to the deep dive. And today we are going to really unpack something that is absolutely like the cornerstone when we talk about professional psychology, and that's confidentiality. Because you are listening to the deep dive, you are the kind of person who likes to know the ins and outs of really important topics. And so you have no doubt run into this idea of privacy. I mean, think about it, your health records, your online data, all that stuff. But this deep dive is really focusing in on what confidentiality means in the world of psychology.
Yeah, absolutely. I think that's a great place to start. And we've actually got some very interesting sources here to really dig into this. So we're going to be looking at the specific laws that we have right here in California, the Lanterman-Petra Short Act, the Confidentiality of Medical Information Act. And then to give us the broader ethical context, we're going to be looking at the principles that are outlined in the American Psychological Association's Ethics Code.
I like it. I like it. So really, our goal today is pretty simple, but it's vital. And that is we want to give you a really crystal clear picture of what it actually means for a psychologist to keep their clients' information private. We'll talk about not just the rules themselves, but like those boundaries, those situations where confidentiality has its limits, and really the why behind all of these rules.
That's a great overview.
So let's jump right in. Like when we talk about psychology, what exactly is confidentiality and why is it such a big deal?
Well, at its core, it's really about this obligation that a psychologist has to protect their clients from unauthorized disclosure of information that comes up, in the course of their work together.
Mhm.
It's really the foundation of trust that allows therapy to even work.
Yeah, if you can't trust your therapist, it's not going to work.
It's not going to work. And it's not just like a really strong suggestion. It's actually, a legal requirement under California law, and a really fundamental ethical principle for psychologists everywhere.
So let's talk about some of these laws. You mentioned the Lanterman-Peters Short Act, the LPSA. What is like the essential thing to know about that particular law as it relates to confidentiality?
Okay, well, the LPSA, that specific law, really addresses the confidentiality of mental health information for folks who are receiving services either within the public mental health system or, in psychiatric hospitals. And that can be like voluntary or involuntary hospitalization. And basically, it sets up this very strong expectation that this information is going to be kept private.
So it sounds like California law really creates this like strong presumption of privacy, but as you said, there are times where that privacy can be kind of overridden. What are those specific exceptions under California law where a psychologist can share information without actually getting consent from the client?
Yeah, there are a few. They're carefully defined. So California law permits disclosure in situations like a true medical emergency, if a client is in imminent danger to themselves or others, and when there's a legal obligation to report suspected abuse of a child or a dependent adult.
Okay. I guess those all make sense in terms of protecting people.
Yeah.
Now, you mentioned that sometimes the LPSA and the CMIA might kind of bump into each other a little bit.
Uh-huh.
What happens if they don't agree when it comes to like a specific case?
That's a really good question, and it's a really important point to understand. So if there's a conflict between the LPSA and the CMIA, specifically for patients who are either in the public mental health system or in inpatient psychiatric facilities, the LPSA actually takes priority.
Okay. So in those settings, then the LPSA is really the guiding law when it comes to confidentiality.
That's right.
Okay, so we've talked about when disclosure is permitted, but there's also times when psychologists are actually legally required to break confidentiality. And that sounds like a pretty significant responsibility.
It is, yeah. And there are several legally mandated situations where you have to breach confidentiality.
Okay.
The first one is if a client tells you, the psychologist, that they are going to commit a violent act. So let's say a client communicates a serious threat of physical violence against a reasonably identifiable person or persons. The psychologist has this legal duty to take what we call protective actions, which can include things like warning the intended victim, notifying law enforcement, trying to get that person hospitalized. And this is really important because you have to, as a therapist, you have to assess, is this person actually going to do this thing?
Right.
And so there's a lot of ethical, legal considerations around that. And there are serious consequences if you do act and if you don't act.
Yeah, I bet. That sounds like a really tough job right there. Yeah.
It is. It is. The second one is a little bit more straightforward.
Yeah.
And that's if a psychologist in their professional capacity learns or reasonably suspects that a child is being abused or neglected, they are legally mandated to report that. And that goes to Child Protective Services.
Right. Makes sense.
Yeah. And similarly, there's a mandatory reporting requirement if you reasonably suspect abuse, neglect, or abandonment of an elder or a dependent adult.
Okay. Those all make sense in terms of safeguarding individuals.
Yes.
Are there any other like legal requirements for disclosure that you should know about?
Yeah. So, if a court issues a valid legal order,
Mhm.
say a subpoena that requires a psychologist to release client records or provide testimony in a legal proceeding, they generally have to comply with that order.
Okay.
Now, this brings up this whole idea of privilege, legal privilege, which basically protects those communications between the client and the therapist from being disclosed in court.
Okay.
But it's not absolute. It can be overridden by a judge in certain circumstances. So while your conversations with your therapist are generally protected, a court order can compel the psychologist to disclose that information.
Okay, interesting. And then there's the Patriot Act.
Yeah, the Patriot Act.
And that feels like that kind of operates in a totally different world.
It does.
Yeah.
So Section 215 of the Patriot Act, that was enacted in 2001, and it introduced this requirement for psychologists, among others, to provide the FBI with certain client information under very, very specific circumstances that are related to national security investigations.
Oh, wow.
Yeah. And what's really, really notable here is that the psychologist who gets that request, they're actually legally prohibited from informing their client that that's happened, or anyone else.
Wow. That seems pretty wild. Like you can't even tell the client that the FBI is asking you for this information.
That's right. That's right. So it creates this really, really, a lot of tension with those principles of transparency and trust that are so, so essential in the therapeutic relationship. So it's one of those situations where national security concerns take priority.
Yeah. Okay. Well, that definitely adds a wrinkle that I think a lot of people probably don't think about when they think about therapist-client confidentiality. Okay. So that's the legal framework here in California. What about ethical guidelines like from the American Psychological Association? How do those line up with these legal requirements?
Yeah. So the APA Ethics Code actually aligns pretty nicely with these legal requirements.
Yeah.
But it also provides a kind of broader set of ethical principles and standards that guide psychologists even beyond what the law says.
Right.
So Standard 4.05, it's titled Disclosures, and this essentially mirrors the legal framework by saying that psychologists may disclose confidential information, with the client's informed consent or when they have legal authorization to do so. But it also outlines some very specific situations where they may disclose without the client's consent, but only if it's permitted by law and for very specific purposes.
Okay. What are some of those purposes? Like what would be considered like a valid purpose ethically?
So some of the things that the ethics code mentions are, to provide needed professional services to the client.
Okay.
So let's say you need to coordinate care with another healthcare provider.
Right.
That would be kind of an implied consent there.
Makes sense.
Getting appropriate professional consultations with colleagues.
Okay.
So you're talking to another therapist. You're not using the client's name or any identifying information, and that could benefit, the treatment.
Okay.
Also protecting the client, the psychologist, or others from harm.
Okay.
That echoes those legal exceptions that we talked about.
Right.
And finally, disclosure might be permitted to get payment for services. But, and this is really important, the psychologist can only disclose the minimum amount of information necessary for that billing.
Got it. That makes sense. Like you wouldn't share someone's deep personal history just to get paid.
Exactly.
Okay, so you mentioned the ethical considerations when you need to consult with a colleague. So how does a psychologist kind of navigate that? Like how do they make sure they're not violating confidentiality when they're just trying to get advice?
Yeah. So Standard 4.06 really digs into consultations and really focuses on the ethics there. So when a psychologist seeks consultation, they have to only share the information that's absolutely necessary to get that consultation.
Okay.
And importantly, they can't disclose anything that would identify the client unless they have gotten consent.
Right.
So the emphasis here is really on protecting the client's anonymity while still being able to get that expertise from a peer.
Makes sense. This whole thing really highlights, I think, how much care and thought goes into these guidelines.
Absolutely.
And, it seems incredibly important that a psychologist be, upfront with their clients about all this stuff from the very beginning of their relationship. I
Yeah,
think the APA actually has a whole standard on that, on discussing those limits of confidentiality.
they do. They do. Standard 4.02. And this standard, it really focuses on this ethical obligation that psychologists have to talk about those limits of confidentiality and, and also those possible ways that the information that's shared in therapy could be used.
Okay.
And this has to happen with the client and, if appropriate with, individuals who might not legally be able to give informed consent,
Right.
as well as their guardians or legal representatives. And this happens right at the beginning.
Okay.
And it's not just a one-time thing.
Okay.
It's an ongoing discussion as new circumstances come up.
Yeah.
So setting those expectations really clearly from the start is just crucial to building trust and making sure the client is fully informed.
Yeah, I would imagine so. It sounds like transparency is really, really key here.
Absolutely.
Now, what happens if a psychologist isn't working directly for the person who is seeking help, but is like being asked to do something by a third party? So like an employer asks for a fitness for duty evaluation, or a court orders, a psychological assessment or something like that.
Yeah.
How does confidentiality work when you got that other party involved?
Yeah, so standards 3.07 and 3.11, those really address these more complicated situations where there's, a third party, making the request, or the services are delivered through an organization.
Okay.
So if a psychologist is providing services at the request of someone other than the individual who's there.
Yeah.
So that could be like a court-ordered evaluation, or when parents request therapy for their child.
Right.
Standard 3.07, that requires the psychologist to explain, their role and the nature of the relationship with all the parties. And that happens right at the beginning.
Okay.
And importantly, to clarify who the client is in that situation and what the expectations are regarding confidentiality.
Right.
So that everyone understands.
Because who is the client in that case?
Right.
Yeah, that's really important.
And as someone who might be involved in a situation like this, understanding who the psychologist's primary responsibility is crucial.
Yeah, for sure. Everybody needs to understand kind of the ground rules from the get-go.
Yes. Yes.
What about when psychological services are provided through like a bigger organization, so like a clinic or a school or something like that?
Yeah. So standard 3.11, that really helps us here. Psychologists who work in organizations need to make sure that clients and anyone else who's directly affected by their services, that they're clearly informed about what services are offered, who's the client, and really importantly, any limits on confidentiality that might exist because of the organization.
Okay.
So, for example, in a school, there might be different, protocols for sharing information with administrators compared to, a private practice setting.
Right. You gave that example earlier about the fitness for duty evaluations. That seems like a really tricky area where the employer has a real interest in what's going on.
It is.
But so does the employee in terms of their privacy.
Yeah. It's a very, very, nuanced situation. So typically an employer is going to ask an employee to sign a specific authorization to release information before that evaluation happens. But California law, specifically Civil Code Section 56.XC8, it actually recognizes that even if the employee doesn't give full consent, the employer still has a right to receive some very, very limited information. But only if certain conditions are met, like if the evaluation is directly related to the job and paid for by the employer.
Okay. Limited how? Like what can the employer get in that situation without the employee's full consent?
So the law says they can only get information that's directly related to the employee's ability to do their job right now.
Okay.
So whether there are any functional limitations, that might affect their capacity to work safely and effectively, and whether there are any reasonable accommodations that might be needed.
Yeah.
But, and this is really, really important, the law says you can't give the employer any underlying medical diagnosis or the cause of those limitations without that employee's written consent. So it's about their ability to work, not their medical history.
Right. So that's a really, really important distinction to protect their privacy.
It is, yes.
But still giving the employer some information that that they need about their employee.
Yes.
What about employee assistance programs,
Uh-huh.
EAPs? Do those have like different confidentiality rules?
No, not really.
Okay.
In those settings, the same basic principles apply.
Okay.
So that means that, information that an employee shares with their EAP counselor, that can only be disclosed with the employee's authorization, or when there's a legal permission or requirement to disclose without that authorization. So, if there's imminent risk of harm to the employee or others, the fact that the EAP is offered by the employer doesn't automatically create, more exceptions to confidentiality.
Right.
The focus is still on protecting the employee's privacy.
Okay, so let's talk about situations where there's multiple clients. Like what happens in group therapy or when a therapist is working with a couple or a family?
Yeah.
How does confidentiality work in those settings?
Yeah, so multi-client situations, those have a unique set of considerations for confidentiality. So in group therapy, the therapist obviously has that ethical obligation to maintain the confidentiality of each person who's in the group. But other members of the group aren't legally bound by those same rules.
Right.
Right. So Ethics Code Standard 10.03, that standard says that therapists need to really clearly explain those roles and responsibilities of everyone in the group, and the limits of confidentiality right at the beginning.
Okay.
And it's also considered, ethically just good practice to remind the members of the group, hey, be respectful of each other's privacy.
Right. Right.
But, there's no guarantee that everyone in the group's going to do that.
So in that situation, even though it's not legally mandated, there's like a level of trust among the participants that's really important.
Absolutely. Absolutely. And then when you have couples therapy or family therapy, Ethics Code Standard 10.02,
Yeah.
that really focuses on the therapist's need to clarify what's going to happen with that information. How is it going to be used?
Yeah.
And a really common area where this gets tricky is this whole issue of secrets.
Right.
So, for example, if one person in the couples therapy, shares something important with the therapist in an individual session, what's the therapist's policy on sharing that with the other partner?
Yeah.
So it's essential for the therapist to have a clear policy on that and to communicate that very, very clearly at the beginning to avoid, misunderstandings and breaches of trust and potential harm to the relationship.
Yeah. I mean, if one partner thinks they're telling a secret and the other partner finds out that it wasn't a secret, that would really undermine the whole process.
Absolutely.
Okay. So finally, let's talk about confidentiality when the client is a minor. I mean, that's got to have its own challenges because they have legal guardians who also have rights.
Absolutely. So generally in California, parents do have a legal right to be informed about information that their minor child shares in treatment. But there are specific exceptions to that.
Yeah.
And that's, especially in areas like emancipation or when a minor is seeking, treatment for certain things like, substance abuse or reproductive health, although those specific exceptions are probably a bit too detailed for our conversation today. But even when parents have a legal right to that information, psychologists often have to, wrestle with this ethical challenge because full disclosure to parents, sometimes that can really, really undermine how effective the therapy is.
Right.
If a young person doesn't feel like what they're saying is private, they're probably not going to open up and be honest about what's going on.
That makes sense. So how do therapists typically handle this balancing act between, the parent's legal rights and the therapeutic needs of the child?
Yeah. So a very, very common strategy, and one that's often helpful, is to try to get everyone on the same page right at the beginning.
Okay.
So the therapist, the kid, and the parents, they all come up with this agreement that lays out what kinds of information will be shared with the parents and what will stay private.
Okay.
Now, this may not always be, legally binding in every situation, but it really can help build trust with that younger client.
Yeah.
And encourage them to participate while still keeping the parents in the loop.
Right. It sounds like that is a really crucial thing when you're dealing with young folks, and you really have to be, considering everybody's needs and rights.
Absolutely.
So wow, we've covered a lot of ground here today, and it really is clear that confidentiality in psychology is so important. It's backed by law, by ethics, but it's not a 100% guarantee. There are these exceptions that everybody needs to be aware of.
Yeah. That's a really good summary. Confidentiality is, it's essential to the profession because it creates that foundation of trust that therapy really relies on. But it does operate within a system of laws and ethical principles that also recognize those other really important needs, like preventing harm and protecting people. So for anyone who interacts with mental health professionals or whose work kind of touches on these areas, having a solid understanding of both those protections and those limitations of confidentiality is so vital.
And that leaves us with this final thought. Given, this really intricate kind of dance between a client's right to privacy and those exceptions for disclosure, whether it's to prevent harm or legal obligations, or even when you're working with, multiple people or minors, where do you see like the most significant ethical challenges when it comes to confidentiality in psychology? It really is a balancing act, and one that I think mental health professionals are constantly kind of working with, to uphold ethical practice and the safety and well-being of everyone.
Well, thanks for joining us for this deep dive into confidentiality.
Absolutely.
Until next time.